Assalamualaikum warahmatullahi wabarakatuh. So welcome back to our recorded lecture via Zoom. So this is part 2 of the lecture for the topic trespass to land. Okay, in the last lecture, part 1, okay, we have covered basically the rule, the concept, the elements, okay, especially, okay, we discussed quite thoroughly on that. So hopefully you have been you are able to understand whatever that we have discussed so far. So now let's continue further. Okay, this is the continuation, okay, of part 1. So now we are going to discuss the defenses, okay, of trespass to land. And then we proceed with some other subtopics, okay, including remedies. All right, so as far as trespass to land is concerned, okay, there are at least, okay, basically two main defenses, okay, for trespass to land. Okay, the first one is license, okay. So license here, it means, okay, it refers to consent or permission, all right, to enter the land, all right. And license here, it can be in the form of express license, okay, express consent, or implied, okay, we can just infer or imply from the circumstances, or even contractual, meaning that here it is given by way of contracts between the parties involved here. Okay, another defense of trespass to land is justification by law. Okay, whenever the law justifies the act. Okay, for example, police, okay, the authorities, okay, the law enforcement, okay, authorities, they are authorized, okay, to enter the land. All right, we are going to discuss section 16 and 18. This is basically the cross reference that you have to make, okay, to the CPC, Criminal Procedure Code. All right. Okay, for the first defense license, we have the case of Sentul Murni Sinan Berhad and Ahmad Amiruddin Kamaruddin, okay, reported in 2000. Okay, the rule was that, okay, this is the ratio, okay, which we can extract from the case here. It was stated that, okay, a person, okay, is not a trespasser, okay, if he is on land with the permission that is under license, okay, of the possessor, okay, possessor, the one who possess the land. I mean, if you have the permission, obviously the act, it doesn't amount to trespass, and the person cannot be called as a trespasser. Okay, but, okay, all right, what if the license has expired? Okay, all right. So if a license exceeds if a licensee exceeds his license, okay, or remains on the land after it has expired or has been revoked, okay, so the licensee, the person who enter onto the land, all right, becomes a trespasser, and then he may be asked to leave. I mean, he becomes a trespasser from the moment, okay, the license or the consent has expired, or maybe it's withdrawn later. Okay, so so he was a lawful entrant, okay, initially, but later, once the license has expired, okay, or even been revoked here, withdrawn, then if he remains on that particular land, okay, or on the premises, okay, so he becomes the trespasser there and then from that particular moment of time. Okay, another defense is justification by law, okay, especially section 16, okay, it provides, so this is the provision, okay, from criminal procedural code here, all right, it provides, among other things, okay, inter alia, that if any police officer, okay, has reason to believe that any person to be arrested has entered into or is within any place, meaning that here police officer is doing the work, okay, discharging his duty, okay, so the person residing in such place, okay, shall, so it's a strong word here, okay, shall allow him free ingress there to free entry. So meaning that here the person, the one who possess, okay, who has the authority for that place, all right, must, okay, shall allow the police officer to enter the place, okay. And then what if the person residing doesn't want to let the police enter? Okay, if ingress to such place cannot be obtained, okay, it shall be lawful, okay, in any case, okay, in which a warrant cannot be obtained. Meaning that here, that situation, there's no warrant, okay, on the part of police officer here, okay. So it shall be lawful, okay, for a police officer to enter such place and to break open any outer or inner door or window. So mean that here the law allows the police officer to enter, even to do whatever, necessary, whatever reasonable to break open any door or any window. Okay, so it doesn't amount to trespass to land. Okay, so it's a strong defense which is provided by law. That's why it is justification by law. All right. Usually the issue revolving around this defense is that whenever it involves search without a warrant, because if it is search with a warrant, so there's no further debate or discussion on that. Okay, is obviously lawful. Okay, right, justified. But what if the search is without a warrant? Is it lawful? Okay, can the police who conduct the search without warrant be liable for trespass to land later? Okay, according to section, now we are cross-referring to section 62. Okay, just now we were referring to 16. Okay, now we go to 62. Okay, 62. All right, it is stated here. It is provided in the section. Okay, if there is reasonable cause, okay, for suspecting that any stolen property is concealed, okay, or lodged in any place. Okay, so you can read further. So in that particular situation, okay, the police officer not below the rank of inspector. So that's the condition. Cannot be any police officer. It has to be at least minimum inspector or above. Okay, so the police officer not below the rank of inspector may search the place for the stolen property even without warrant, provided there exists reasonable cause, okay, for suspecting that any stolen property is concealed there. Meaning that here the police has all the reason, okay, reasonable cause. All right, that's a suspect. I mean, the police suspected that some stolen property is concealed there. Okay, right. So can actually enter the place, can search the place. Here we have the case of Yong Moisin and Kerajaan Malaysia and another 2000. Okay, one of the issues in this case which is relevant to our topic or discussion here, okay, whether the search without warrant conducted by Inspector Ramli was proper. So obviously, the search was conducted by Inspector Ramli, so it fulfills the condition, and then it was done without warrant. Okay, so this is the observation by the court. Okay, upon examining all the facts of the case, all right. The court held that, well, since there was a strict compliance, okay, with the three major ingredients, okay, major requirements, okay, under section 62, subsection 1, okay, and the main objective of the section actually, okay, to avoid of the, the search was conducted, okay, to avoid the destruction of the gold locket. Okay, that's the item, okay, which the police was searching. Okay, so basically the whole action, the whole act of the police was legal, okay, done by Inspector Ramli, even without warrant. Okay, all right. So basically it fulfills the requirements or ingredients under section 62, section 1 of CPC. Okay, we are done with the defenses. So basically we have two, okay, right? It's either license, okay, you prove that there exists license, or maybe it's under justification by law, especially a relevant section under CPC. Okay, all right. Another subtopic that we want to discuss today is about trespass ab initio. Okay, ab initio, what's the meaning? Okay, that's the Latin term. Ab initio, it means from the very beginning. Meaning that, yeah, you have committed trespass from the moment you enter onto the land or onto the premises. Okay, all right. So it says here, okay, where justified entry on land was abused. So that's the key word here, okay, the main requirement. Okay, so the entrant, okay, becomes a trespasser ab initio. So meaning that here, initially, he was the lawful entrant, okay, but actually there's that it exists. I mean, it involves certain abuse, okay, of the entry. Then it nullified the whole entry from the very beginning. So it means, okay, the original entry becomes unlawful. Okay, all right. So what's the reason of having the rule here? Basically, the rule is from common law. Okay, trespass ab initio is important because why? It protects abuse of authority. Okay, we don't want a person in authority to abuse, okay, whatever power given to them. All right. Okay, this is actually the case which discuss, okay, the rule. All right, very classic case here, reported in 1610, okay, 17th century case. The name of the case is Sick Carpenter's case. All right, so what happened here? six carpenters, okay, they entered and in. Okay, so obviously they were the customer, okay, the guests, all right. So they consume wine and bread, okay, and then they refused to pay. So that's the only thing that they did. Okay, they were legal, obviously. Okay, legal entrant, legal consumer, okay, or guest here. So they consume one, okay, and then they ate some bread, but I'm not sure why they refuse to pay. Maybe no money whatsoever, right here. So the issue here, right, whether their non-payment made the original entry unlawful, because originally they were lawful entrant, all right. So this is the rule, okay, which we extract from the case of six carpenters here, okay. The court held that one entry, okay, authority or license is given to anyone, okay, by the law, and who does abuse it, okay. So in that situation, he shall be a trespasser ab initio. So we apply the rule to six carpenters case here, okay. On the face of the case, okay, defendants, the six carpenters, were not found liable as trespasser ab initio. Why is that so? Because the court held that their non-payment, they omitted to pay. Okay? Their non-payment was merely an omission and not a positive act. So abuse here is non-payment. So that one the court treated as it doesn't amount to trespass ab initio. Okay. So non-payment is omission. But if the six carpenters did something positive, for example, they were involved in fight, for example, okay, they hit the waiter, for example. So it might amount, the whole act, okay, is positive act. So the rule of trespass ab initio can be applied in that scenario. But as far as the case was concerned, okay, it doesn't amount to trespass ab initio. So they were not trespassers ab initio. They were trespasser, but then as with regards to their non-payment, all right, the omission, but not trespasser ab initio. Okay, so for trespasser ab initio here, we have actually three conditions, right, that must be fulfilled in order to apply the rule. Okay, the first one, okay, the entry is given by the law and not by the other party. So the law allows the person to be there. Okay, and then number two, the abuse must be a positive act, not a mere omission, like the one which happened in six carpenters case. Okay, this one not fulfilled. And number three, the third condition here, okay, the abuse must take away the entire ground of the entry. Okay? If there remains any independent ground of entry which is unaffected by the abuse, the entry is justified and doctrine does not apply. So we have the case actually to illustrate this. Okay, this is the case. Elias and Passmore, okay, 1934, also common law case here. So police had lawfully entered plaintiff premise, okay, in order to arrest a man. So that's the what the police did, okay. And while on the premise here, they seized, okay, so they took, okay, right, a number of documents, okay, some of them lawfully but some unlawfully. So it missed out of documents here. Okay, some actually were the documents that they were searching, but some actually not. Okay, unlawfully taken, unlawfully seized here. That's why plaintiff is suing the police. Okay, but for trespass ab initio, the court held that, well, the act of seizing these documents, okay, here, it did not render their original entry a trespass. Okay, what's the real reason, okay, to arrest a man here, right? They were trespasser, yes, only to the documents which were unlawfully taken. Very limited act here, okay, right? And the police were not liable as trespasser ab initio for damage to the premises which they had lawfully entered for the purpose of the arrest. So whatever they did in order to arrest the man, so it is still considered as lawful. Okay, but they are trespasser with regards to the document, okay, which they were not supposed to seize here. So it doesn't make the whole entry, the whole entrance, okay, here, trespass ab initio. So that's the case. Okay, we are done with trespass ab initio. Okay, the next part of our topic today is remedies. Okay, what are the remedies? The usual remedy for torts law, okay, you are asking for compensation and injunction. Okay, but as far as trespass to land is concerned, okay, we also have another remedy which is actually specific to this trespass to land. Okay, the remedy here is a rights of re-entry. Basically, this is something which is subhat. Okay, it is beyond whatever being provided by law or judicial remedy. Okay, here So it is right of re-entry here. It is an extrajudicial remedy, or we call it as self-help. Okay, actually this is from common law. Okay, common law rule here. So the real meaning is that it implies retaking possession, okay, of it by his own act, okay, using no more force than necessary. So certain boundary or limitation here. They cannot do such an act which is not allowed by law. Okay, all right. Okay, we have the case, this is local case, right? Trustees of Leong Santong Ku Kongsi, Penang, and Po Swee Siang, okay, 1987. So it involved landlord and tenant. This is an appeal case, all right? A, the appellant, okay, the landlord. So the landlord had issued a notice to quit to the respondent, the tenant. I mean, you have to leave, I mean, you have to move out from the premise here. So the court held that, this is the finding, okay? On the expiry of the period specified in the notice, okay, actually respondent, the tenant, became trespasser on the land, no longer a lawful tenant, but trespasser, okay, all right. So appellant, the landlord, could enter the land, okay, to evict respondent using, okay, no more force than necessary to achieve the object. Of course, cannot involve whatever criminal act, okay, cannot hit, cannot punch whatsoever, okay, all right, do whatever reasonable, okay, necessary to achieve the object. And then we need to cross-refer to section 7 of SRA, okay, Specific Relief Act. It used the word may, okay, it allows, okay, the remedy of self-help here actually, okay, and self-help is the common law remedy. Okay, this is section 7, a Specific Relief Act 1950. It provides, okay, a person entitled to the possession of specific immovable property, for example, landlord just now, okay, may recover it, okay, in the manner prescribed by the law relating to civil procedure. Actually, this is not the full provision. You can read later. But the word may here, I mean, you can go by way of law. You can also do whatever necessary on your part, self-help. Okay, you help yourself. Okay, and section 8, the same act, SRA, okay, it provides if any person is dispossessed, okay, without his consent of immovable property, otherwise, then in due course of law, so he may, by suit, okay, recover possession thereof. So he can do so by way of legal suit, filing a legal suit. So now we want to know who can sue for ejectment, okay, who can file the suit, okay, to eject the person, to eject the tenant, for example, okay, all right. So basically the rule is that, okay, any possessor, okay, I mean the one who possesses the land, okay, of the land can sue, okay. For example, in the case of Ng Bong Tong and Krishnan, okay, 1998 here, the court held that since the defendant being an illegal occupier and he was actually a squatter, so squatter is illegal occupier. So plaintiff, okay, the owner of the land has the right to eject and evict him. Okay, notwithstanding the fact that he occupied the land, but actually he was a squatter, no right whatsoever. And also the person who can sue also includes a toll holder. Toll is temporary occupation license, license given to certain person. Okay, so they hold the license temporarily for some time, maybe 2-3 years. All right, so they can sue provided their license, the toll license here, is still valid. Okay, it doesn't expire. So this is the case Julaika Bibi and Mudin, okay, 1961. Plaintiff, the holder of the toll, okay, so alleged that defendant was in wrongful occupation of a house on the said land and claimed for an order for ejectment. Okay, meaning that here plaintiff is the holder of the toll. Okay, but then defendant said, this is argument defense, okay, put forward by the defendant here, Mudin, I believe. So plaintiff is Julaika Bibi. So defendant argued that he had been in possession of that house with the consent of the previous holder of the toll. Actually, this is argument, okay, by defendant, I'm the owner, the holder of the toll. Okay, you have no right because I mean I get the consent from previous owner, previous holder of the toll. Okay, but the finding by the court, this is a decision. Previous toll actually already been cancelled. Okay, so now defendant was a trespasser against plaintiff. So plaintiff has better right. Okay, plaintiff is the new holder of the toll, the valid holder of the toll. Okay, so holder of a toll may bring an action for ejectment against a trespasser. In this situation, defendant is the trespasser. Okay. Alright, another case here, Muhammad Said and Fatima, okay, 1961. Okay, alright. The court held that, well, since plaintiff toll had already expired, similar to July Kabibi just now, okay, and he had not yet renewed, okay, he had no right to sue for ejectment. I mean, once the license expire and it's no longer a valid license, okay, no right to sue whatsoever. In fact, you can be sued for being trespasser if there is a new toll owner, okay, I mean holder of the license. Okay, the last part of our discussion, okay, for this topic is pertaining to adverse possession. Okay, so what is adverse possession? It means the actual possession. I mean, you possess, you physically possess the land, okay, landed property, the premise, okay, the house, okay, in the absence of possession of the rightful owner. Meaning that here, those who has this adverse possession, actual physical possession, but you are not the rightful owner, okay, whether you can actually own that particular property or not here, okay, all right. So basically, adverse possession is a principle of English common law, okay? So it is no defense to an action for ejectment. You cannot defend yourself by arguing adverse possession. But at common law, okay, if the adverse possession continues without protest, okay, at the expiration of the prescribed period, normally 20 years, okay, the title of the former owner is extinguished. Meaning that here, if no one, okay, is claiming the right over the property, okay, you have been possessing the land for 20 years, okay, without protest, okay, without suit whatsoever. So actually the real owner lost the title over the land. Okay? That's the rule at common law. You can dispossess the real owner, the rightful owner. Okay? You are the new owner for having this 20 years adverse possession. But in Malaysia, we don't follow, okay? So adverse possession has been abolished, okay, by the promulgation of the NLC, National Land Code 1965, okay? Especially under Section 48, it says clearly, okay, there can be no adverse possession against state land, okay? After all land, okay, belongs to state, okay? It's a state matter. Okay, and then section 341 of the same act, okay, so we read together, 48 and 341, okay, of NLC here. It protects the interest that a person has over his land, okay, by providing that any adverse possession against him does not operate to extinguish his interest should he one day decide to recover the land. So no certain time, okay, no, I mean, for example, at common law 20 years, okay, in Malaysia, 20, 30, 40 years, no, it doesn't make you the new owner if you have this adverse possession over the land. Okay? It doesn't give you any rights. Okay? So that's the case, okay, Yap Lai Yo and Chin Fuk Wah in 1984. So plaintiff was registered proprietor of a land, so he's the land, I mean the rightful owner, okay, the lawful owner. He claimed that the owners of adjoining land had unlawfully built extension to their buildings, okay, thereby encroaching on his land. So it encroached the land belonging to plaintiff here. So because of that, he brought an action for trespass against the defendant. But defendant rely on the defense of adverse possession. You never complained before. That's the adverse possession. Okay, we physically possess the land, okay, by building this certain extension here. All right. The court held that adverse possession is no defense, okay, under section 341 of NLC. Okay, a true owner, plaintiff here, right, can never be dispossessed of his land. Adverse possession by a person for however long period does not extinguish the title of the registered proprietor. It doesn't matter, even 100 years, okay, it doesn't make you the new owner. Okay, we don't, I mean, in Malaysia, we don't recognize adverse possession as opposed to common law. Common law, if 20 years, okay, without protest, adverse possession, I mean, the one who possess the land, okay, can actually become the new owner, extinguishing the earlier owner, the rightful owner. All right. Okay. We are done with the topic trespass to land, okay. All right, I hope you have been able to follow, okay, to understand the rule, okay, pertaining to trespass to land. Okay, with that, we are going to continue later with the next topic. All right, so Assalamualaikum warahmatullahi wabarakatuh.